Be no contact with Monica Tobias. Court is going to find you guilty. Court is going to sentence you to 8 years in the prison.
On him.
Court will give any 2023 CR 4230, State of Texas versus Darianne Renee Delarosa. Could I have parties announced for the record for the state? Defense?
Charles Goldar.
Are you Ms. Delarosa?
Yes, ma'am.
Showing you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it? Are you the same Darianne Renee Delarosa who was placed on deferred adjudication in 2023 CR 4230 for the offense of robbery on July 17, 2023 for a term of 5 years? Is that you?
Yes, sir.
State?
Yes, Your Honor. Violated condition number 56 on or about the 30th day of January 2024, Revere County, Texas, the defendant Darianne Renee Delarosa presented there failed to comply with the rules and regulations or instructions of the Revere County Supervision and Corrections Department's duly diagnosed residential facility, and the defendant refuses to participate with the required program violation number 56.
How do you plead to that? True or not true?
True, Your Honor.
Did you understand by pleading true to violation of 56, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, sir.
Knowing that, do you still wish to plead true to violation of condition 56?
Yes.
Court will find it true. Is there a proposed agreement?
There is, Your Honor.
Yes.
It is to keep the individual on her probation or deferred to deny motion and alter and amend the require her to attend safety.
Okay, why is she not going to DDRF? That's my question, because that's what I ordered.
The information that was received from DDR was she did not want to participate.
All right, so you can participate at the prison, but it's not going to be at Safety. This is not Burger King. People do not get to have it their way. I ordered DDRF, and you don't want to go there. So what's going to end up happening? You've been here before. The court is going to find you guilty. Now, how much prison time do y'all want to ask for?
There's a state, maybe requesting 5 years, Your Honor.
I would ask for two, Judge. She's willing to go to safety. She wants to continue with drug court. We would ask that you reconsider and consider safety. We understand that's going to be 9 months long with aftercare. She's willing to do that.
Okay, this is what the court is going to do. As previously stated, the court is finding violation of 56 true. The court will find you guilty. There's to be no contact with Monica Tobias. Court is going to find you guilty. Court is going to sentence you to 8 years in the prison. Court will give you credit for any time served. Court will retain jurisdiction.
Thank you, Judge.
All right, I'm showing you what's entitled, showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? All right. Because this is not a plea bargain agreement, you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you are on probation. Do you understand? All right, we can go off the record. So, Ms. Delarosa, when you're sent to certain programs, I'm not just doing it because, hey, let's just do this for no reason whatsoever. There was a reason you were sent to that program. You do not get to write your own programs. If you could write your own program and be successful at it, you wouldn't be in court. You would be successful. All right, good luck to you. Court is calling 2022 CR 2755, State of Texas versus Luttrell Miles. Can I have parties announced for the record for the state?
Daniel Escobar, State of Texas.
Defense? Defense?
Natasha Thurston on behalf of Mr. Miles, Your Honor.
And are you Mr. Miles?
Yes, miss.
All right, Mr. Miles, did you have sufficient time to speak to your attorney?
Yes, I did, ma'am.
All right, counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Miles, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We waive, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Miles, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 1 gram to 4 grams? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, I did, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Miles, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 4 years in the prison. The state is silent on your application. They're taking in consideration NIMAG number 712181. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Judge, yes, but just with one addition, in speaking with defense counsel, one term that wasn't added, because my understanding is that they're still going to ask for a bond to be set while sentencing is pending, is that if the defendant does not appear for sentencing at the designated date, that he is open to the full range of punishment.
All right. Did you understand that?
Yes, I did.
Does anyone want to write that in?
I will,
I
Judge.
think
Sure.
you're writing.
Thank you. So you understand if you do not appear at your sentencing, then you'll be subject to the full range of punishment?
Yes, ma'am.
And you understand that the full range of punishment is up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Did you review the paragraph with your attorney entitled waiver of appeal paragraph, and did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counselor, have there been any such motions?
Motion's filed, none ruled on, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Okay.
State any evidence?
State overstates to the one in all attachments.
Without objection, Your Honor.
Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Sorry, Your Honor.
No problem. Thank you. And what is the case that's being taken into consideration?
It's another drug offense, Your Honor.
All right. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. On this case, state, will you be able to present to the court a different date for his criminal history and NCIC and TCIC?
What do you mean, Judge?
Oh, his history.
Oh, just to run it again?
Yes.
Yes, Judge, we can.
All right. Then what we'll do, because I want to know that will help me make a determination on whether or not to grant his application or not, because otherwise, if we don't do it that way, his reset date is going to be far off. So when do you all think you'll have that?
It shouldn't take that long. It could be done in minutes, really.
Oh, in minutes?
Yeah, as long as we tell our investigator and he has the time to do it.
Well, all right. So if we come back the week of July 5th, would you all be able to have it or do you need more time?
We would give that, Judge.
Your Honor, I apologize. I'm scheduled as number one for a jury trial in Maverick County. I'm the only trial.
Okay. And which date is that for you?
It's going to be July 5th. I'm not sure if July 7th is, it shouldn't be more than 2 days.
But you all are in. How about if we put it on maybe July, Norma, can we do July 10th that week? All right. Is everybody okay with the week of July 10th?
Yes, Your Honor.
Same, Judge.
All right. What date? All right. So we're going to come back on July 10th
Yes, Your Honor.
and I'll base my decision off any evidence that's presented to me. So if there are some witnesses you won't, let your attorney know and I'll listen to those as well.
Okay, ma'am. Thank
So
you.
your choice is, do you all want the PSI? Because if you want the PSI, it's going to be far off, or either I can make my decision based upon the criminal history. It will be the criminal history and witnesses. And honestly, the pre-sentence investigation report, they interview you, which if your attorney wants to call you as a witness, I can hear, and they tell me what your criminal history is. That's basically what it does. And then they give me a recitation of the narrative from the police report, which you all have already stipulated to. So as far as your upbringing, where you went to school, who your family is, how you feel about this case, that's something, if your attorney wants me to know about, you can tell me on July 10th.
We'd probably waive PSI, Your Honor.
All right, so you want to waive the PSI?
Yeah.
Okay. Yes. All right, so if you can give a reset form, we'll see you back on July 10th, and at that time, I'll make my decision, okay?
Okay, thank you, Judge.
All right, you're welcome. Yes, do you still want to make the bond, or you just want to wait till July 10th?
Would like to have the bond considered.
All right,
Thank you, Judge.
you're welcome. All right, are you all ready on Priscilla Amaya?